both our liberties of speech and our responsibilities, goals, uses of our speech, our learning, become the people we want to be community members, to be civic actors. So AU is unsurprisingly leading the way in this regard. So we're great. Professor Epps is better though, so that's why he's here. So this is our very first event. I'm really pleased that he can be here. Just by way of a brief introduction, Professor Epps is, in addition to teaching law at the University of Baltimore Law School, is also a frequent contributor to The Atlantic, where those of you who have taken classes with me will notice that, that guy looks familiar from the biopic of all of The Atlantic articles that I assign you. So he's really needs no introduction, but you should also follow him on Twitter at Prof. Epps if once you like what you hear now, you can do more of it. This talk is going to be somewhat interactive. We're going to be a learning community. So there are going to be times when you can jump in or be asked to jump in. Please be your AU selves. I know you spend all of your time arguing in dorm lounges. You have to have something left over. So be you, do you. When you do have questions, Daniel back there, who actually is why this event is happening and got this all done. Daniel back there actually has the mic so that your questions can get into the video. We are doing a video, so I guess save your robust, nasty, or interpersonal dialogue later, or don't text. But he has those mics so they can be picked up, and they have a button on the left that you press down, and when you see a green light, then your mic is live, and then you press it again to make it red to mute it. So we'll make sure we get those mics to you as questions happen. All right.
Come on. I'm a professor and a state employee, and I don't get a whole lot of applause, so I want to maximize it when it comes. Let me move this down so I don't boom at you. I note, first of all, that I'm starting out the event on a higher level than you guys, which I would prefer not to do because I think dialogue about free speech is better than lectures about it, as you'll see. But I'm not sure everybody could see me if I went down, so except that I'm aware of the anomaly given what I'm going to present. But what I would like to say, first of all, is a couple of times, as Professor Schwartz said, I will stop and say, what do people got to say about this? But in the interim, if I say something that you're curious about, you don't understand, or you think is wrong, just raise your hand. I'm not, like a train. I'm not going to steam past you. But I want to talk a little bit about this topic of civil discourse and how we think about freedom of speech. Because freedom of speech is one of the very central American cultural and political values. But I find that our understanding of the concept, our willingness to explore it as a culture, is more limited than I would like. And I want to start by exploring very briefly an event a historic event that has just happened, that has produced and will continue to produce large-scale effects, but that was accomplished entirely by means of speech. And what I refer to is the recent confirmation of Brett Kavanaugh to the United States Supreme Court and the attendant dispute over that began at the hearings and continued. Because we had 3 acts of speech that define that. It's almost like a 3-act drama. And the first act is Professor Ford's testimony in front of the Senate Judiciary Committee, in which she said, basically, I know you don't know me, I know you don't know who I am, I have no reason to lie to you, I didn't want to come here today, I'm just an ordinary person, I feel it's my duty to tell you what happened to me, and here it is in all the detail I can offer. And that produced, effects on a lot of people that heard it. Many people believed her, Other people had questions. But the next act of the drama, of course, took place that afternoon when Kavanaugh himself appeared and testified in a very different rhetorical mode, if you think about it. To begin with, he was able to make what rhetoricians call an ethical appeal that was not available to Dr. Ford. And by ethical appeal, the rhetoricians meant the statement, or implicit or explicit, that I am a good person, I am the kind of person you should believe. And that was a great deal of what Kavanaugh said in his testimony. I've been a judge for 12 years, I've been in public service my whole life, I went to the very best law school, I worked very hard, I feed the homeless, I'm a good person. And that really took the place of any detailed discussion of the specific allegations that had been made against him by Professor Ford. He would not engage with them. He would not really say, whether he had any memories that might match up with hers. He simply kept saying, I am a good person, I live on the sunrise side of the mountain, and so forth. And at the same time, unlike her, he was able to quite successfully express anger to the extent that he actually was able to invoke his own social and governmental position to dismiss United States senators who were there to ask him questions, which was the putative purpose of that hearing. So we had those two acts, and while the public was kind of digesting what went on, the President of the United States got involved, and this is the third act, and having initially said, well, I feel bad for her, her testimony is credible, and so forth, he went to a rally of his supporters the following weekend and called her testimony a hoax and mocked her in his inimitable fashion, kind of did his kind of imitation of her, I don't remember. And these three things, these three events have changed the debate in this country over a number of topics, beginning with sexual assault, but not limited to that. And according to preliminary public opinion research, they may actually change the result of the November elections. They may actually have rallied the president's credibility with certain groups of people, may have rallied voters who otherwise might not go to the polls, with the result that control of the government will possibly stay in the hands of the president's party. Now, that's a pretty big effect to come entirely from speech. So I think we have to begin with the concept that speech is very powerful. And I think we have to go further to say that the context of speech and speaker make a tremendous difference. That when someone, like Professor Ford, who really presented, and I think credibly presented as sort of the most ordinary American, a person who was just trying to live her life out of the public view, but felt that she had to speak out of duty, is contrasted with that of a government official, like a person with great social power, like Judge Kavanaugh, and then finally taken up by the president, who has the power, in essence, to monopolize public discourse for a greater or shorter period of time. You can see that speech, it's almost kind of a mystification to say that we're talking about the same thing, that we're talking about speech. And I hasten to add that nothing in my discussion was intended to prejudice the question of who was telling the truth and who wasn't. I have my own views on that, but I think anybody who witnessed that event could agree speech is very powerful. Nothing happened in that entire historic episode except 3 people using their freedom of speech. And the result is that society has changed, perhaps on a long-term basis. And so I think that the ability to analyze speech questions needs to involve context, speaker, social power, political power, all of these things. And I want to point out how that plays out or doesn't play out in our current law of free speech by looking at a case decided about a month ago called Nwanguma versus Trump. I don't know how many people have heard of this case, maybe not by that name, but the case arises out of a rally that was held during the 2016 campaign in Louisville, Kentucky. It might have been Nashville, but I think it was Louisville, in which Mr. Nwanguma and several other people arrived, and they were present lawfully in the rally with the purpose of protesting Mr. Trump's speech, perhaps briefly disrupting it, not by rushing the podium, but by standing and speaking at their seats or in the aisles. And Mr. Trump, confronted with this challenge and standing in front of an audience of thousands of people who were his supporters, because that's who went to those rallies, said, "Get him out of here." And he pointed to the door and said, "Get him out of here." And there was scuffling broke out in the crowd, but he said, "Don't hurt him." And the allegation in the complaint by Mr. Nwanguma and the other plaintiffs was that they were roughed up. I don't think they were seriously injured, but they were legally speaking assaulted. Hands were laid on them by people in the audience, and they were forced out of the rally. And they filed a lawsuit against now President Trump, alleging something that is fairly straightforwardly not protected by the American law of freedom of speech. And that was, they alleged that Mr. Trump had incited violence. And those of you who study the law of free speech will find two things. One is, incitement to violence is not protected by the First Amendment. That's thing one. But thing two is, incitement to violence is defined very narrowly in our law, so that you almost can never actually get there. And this case was dismissed by the trial court, and it was appealed to the Court of Appeals for the Sixth Circuit. The dismissal was appealed. And the Court of Appeals did something that probably won't strike you guys because your minds are not fouled by legal training yet, but to a lawyer seems quite remarkable, and that was as follows. The plaintiffs had alleged that what Trump did in that rally, saying, "Get him out of here," pointing to the door, with standing in front of his large crowd, that it violated a Kentucky statute called inciting a riot. That was the only legal basis on which they could sue Trump. There is no sort of general law that you can sue under that you can't get people beat up. There has to be a statute. And the truth of the matter is, the way the statute was written, and let's see if you can follow this, because my students sometimes take 2 or 3 steps to get through this. The way that statute was written, what Trump did probably didn't violate it. The statute requires sort of more than just standing in front of a group of people and saying something that moves them to violence. It requires an actual riot, because that's why it's called inciting to riot, right? So under the rules that courts ordinarily proceed under, if the plaintiff comes in and says, "You violated a statute," and the law is such that no matter what, the defendant did not violate that statute, the defendant did not incite a riot, then what you're supposed to do as a judge is just dismiss the case. Say, we don't have to reach any constitutional issues, we don't have to discuss the meaning of free speech, because there's no law under which we can award damages to these plaintiffs. But the Sixth Circuit did something somewhat remarkable, And in fact, one judge of the three-judge panel protested and said, why are we doing this? Because having started out their opinion by saying nothing Trump did violated the statute, they then said, but we will go on to decide the First Amendment issue. Arguably, they didn't even have jurisdiction to do that, right? But, and the reason I belabor this point, such is the American enthusiasm, cultural and legal, for a certain theory of free speech that they almost couldn't resist. They almost couldn't resist being part of the chorus. Now, does everybody understand what I'm saying, why it was odd for them to go forward? Everybody got that? Because if you don't, please raise your hand. It's lawyers always take situations that seem clear, right? This is what we do, and break them up into little parts that seem incredibly confusing and then put them back together wrong. And this is a classic example. And I've always said that, I don't know how many people here have read Howl by Allen Ginsberg? Anybody? One of the great American poems of the 20th century that begins, I saw the best minds of my generation destroyed by madness, starving, hysterical, naked, crawling through the streets at dawn looking for an angry fix, describing the desolation he saw in 1950s America. And you read that poem, just as a human being, and it gives you the shivers. It's so powerful. If you're a lawyer, however, you get to the first line, you say, I saw the best minds of my generation, starving, hysterical, naked. And the lawyer says, excuse me, if I could just interrupt here. You state, I saw the best minds of my generation, starving, hysterical, naked. Could you please specify for the record which were starving, which were hysterical, and which were naked? Right? That's what we train lawyers to do, and I get well paid for it, so I'm down with it. But so you have to take clear situations and break them down into steps, and there are two steps in this situation. First, did the defendant violate the law? The answer is no. Okay, we can go home. No, we're going to talk about why the defendant could do whatever he wanted, why the defendant had the right to do that. And they concluded that Trump had every right to stand in front of that angry crowd, point at the exit, say, get him out of here. Even though, at that stage of the litigation, the facts in the record indicated that the plaintiffs were in fact assaulted, more or less as a result of this. He still had the right to do it. And they relied for that proposition, which I think was probably not clearly wrong, on a case also in the Sixth Circuit that I want to throw out here because I think it gets people involved, called Bible Believers Incorporated versus Wayne County, Michigan. And Bible Believers is a case that arose out of an event called the Arab American Festival that was held every year in Dearborn, Michigan. And I think some of you are probably aware that Dearborn, Michigan has the largest sort of concentration of Iraqi Americans, Arab Americans, Muslim Americans of any community in the country. It's a kind of a cultural center for that community. And a group called the Arab American Chamber of Commerce every year put on this festival. And it was, it was like a fair, right? Mama Ayesha's falafel kitchen, and mosques would be there, cultural organizations, there'd be performers and so forth. Just the kind of thing that happens every day across America. It just happened to be an Arab festival and predominantly Islamic. Well, a group called the Bible Believers decided they were called by God to attend this, and they carried with them the head of a pig on a stick, because they said later, Muslims are afraid of pigs. And they invaded they walked into, I don't want to use tendentious language, they walked into the event, which was open to the public, and took up a position, and one of them began preaching, and they were brandishing the pig's head. There's no evidence that they used it as a weapon, but they're holding this pig's head and insulting and saying, you believers in Islam, you are going to hell. Your prophet, horrible libels against the prophet Muhammad, which I won't repeat, but you're all familiar with. And a group of teenage boys began throwing milk bottles and various things at them. The police came along and told the kids to knock it off. These guys went on with the preaching. Sort of violent reaction began again, at which point the sheriff's deputies said to the Christian missionaries, you guys have got to go. You have to leave, right? This is disruptive, and you're causing violence. You have to leave. And they said, well, we have a right to be here. And they said, I don't have, the officer in charge says, I don't have enough deputies to protect you. You're deliberately inciting this, or causing this violence. And the Bible believers left, and then on their way home, they were pulled over and cited for broken taillight, right? So the cops were kind of displeased with them at that point. Broken taillight means I'm really cheesed off at you, right, if you speak police. So they then sued, right, and won damages against the county, and this case was upheld. This verdict against the county was upheld by the Court of Appeals in a very broad opinion that basically said, this violated their freedom of speech. The police had an obligation to protect them. The police had argued they didn't have enough people on the ground. And the court said, we find as a fact that the police did have enough. We don't care what they said. They did have enough. And these people had a right to be there, and their rights were trampled. And there's a couple of things I want to say about that. First of all, under the existing law of the First Amendment, that decision was correct. All right. I don't see any flaw with it. But as in the Nwanguma case that we just talked about, there's a couple of things that are missing from the way we talk about free speech, and that don't show up in court cases, that I think, if you think about it with your non-lawyer head, seem quite important and need to be stirred into the way we think about free speech, right? And the first is the various positions of speakers. By the way, I meant to add, as a result of this lawsuit, as a result of this event, the Arab American Festival of Dearborn, which was, as I say, an event of national importance, was canceled. The insurance company said, we can no longer insure it, and so there is no more Arab American Festival. That's been shut down. And, we can draw our own conclusions about the extent to which that was the intention of the Bible believers. But the cases deliberately don't consider certain things. And if we go back to the speech event with which we began, and think about the social position of the three people, and then go back to the remarkable thing about the Blasey-Ford event was how it was a remake of something that had happened before you were born, but I remember vividly. And that was the hearings in which Clarence Thomas was accused by Professor Hill of having engaged in sexual harassment, not assault, but very close to the two charges were very close. So race made those two events quite different, as well as gender, the power imbalance among the three people. One is the President of the United States, one is a federal judge, one is this woman no one's ever heard of. The same thing carries over and is never discussed in any of the other three cases that I began talking about. Nwanguma, I think we have a hint in the name of the case, Nwanguma versus Trump, that there's more than just two guys here, that this was an African or African-American plaintiff standing in the middle of a Trump rally attempting to peacefully protest. And, taking, I think, a considerable risk. I'm going to be honest with you. I wouldn't go to a Trump rally. And in part because it's a lot of your life that you would spend in a fairly stultifying environment, but it's also, it seems like dangerous territory, especially, for somebody who partially works in the journalistic sector. Nwanguma and his companions went there. And the second thing that is not noticed, that is not mentioned, that is not even discussed, in the opinion is they went there to engage in First Amendment activity. They went there to engage in peaceful protest. Yes, ma'am?
Are you finished with your statement?
It doesn't matter.
Okay, just a question I have.
If you wait for me to stop talking, you'll be here a long time. So go ahead.
Just a question I had was, this probably won't happen in this administration, but I was wondering your opinion on whether there's going to be legislation in the future about free speech versus hate speech, and like hate speech like provoking violence, and like possibly like a law about like the legal line of free speech.
Well, my guess is just at the bottom line of your question that that's not going to happen anytime soon, right? We see some pushing and shoving, but right now, and I think we're going to talk more about that precise question before I finish. But right now, we're at the area of thinking about how that would work. That's what, as a society, we're still thinking. Would that work? How would it work? How would you define that? We see various campuses trying to deal with administrative codes that have to do with this, and it really is quite difficult. And one of the things that we as a society may conclude is that it's just not possible to do it in a way that doesn't do more harm than good. But it certainly right now isn't going to happen because the national dialogue, and I know you guys had my friend Josh Blackman here, and Josh undoubtedly referred to the fact that some people had demonstrated at one of his speeches when he went to City University of New York. And Josh and a number of other people really take the view that the real threat to free speech in our society is here. It's on campus. It is students. Students are the real threat. I questioned that, to be honest, right? That's not to say that I endorse what every student group is doing, but I think if you look at the larger society, you look at some of the things we're just talking about now, there are bigger threats out there. And those threats are almost so large and so powerful that it makes people uncomfortable to talk about them. And some of the discomfort arises from the things I'm talking about now, which is, power dynamics among groups. That Mr. Nwanguma was a black man protesting peacefully in the middle of a angry white crowd, really taking a tremendous risk. And that protest was silenced when candidate Trump said, "Get him out of here," right? There's no inevitability to the idea that protesters have to be escorted out of a rally. They could be allowed to chant and sing. I mean, one person, 3 people, 5 people. Are they really going to drown Trump out? Probably not. And the same analysis could be applied, it seems to me, to the Bible believers' case in the following sense. No notice of this was taken by the majority. There was a dissent in the case by a judge who said, look, we need to evaluate this event, this disruption and violence that are, low-level violence, but violence, that took place at the Arab American Festival. We should evaluate it in the context of the fact that this is a minority religion in this country, one that has been stigmatized, that is the object of widespread hostility and discrimination, that is being disrupted by representatives of the majority religion, by which I mean Christianity. Obviously, the majority of Christians are not like the Bible believers and don't go around with pigs' heads and so forth. But we need to consider that. We need to consider whether the speech that the people at the festival were engaged in is worthy of solicitude equal to that of the speech of the protesters. And there was a separate concurrence by my friend Judge Boggs, who just ridiculed this idea. We never think about that. Minority, majority, it's all the same. Everybody's got free speech. So I think those 3 things set the table for a discussion of whether it is possibly relevant to analyzing a free speech question, what the relative power of the speakers is. And I think there's an up and a downside to that. I mean, I think there are counter-arguments, but it's something that doesn't usually get talked about. And I see a hand, and this is about the time that we should. Yeah, you. Oh, you were looking for the mic. Sorry.
So my question is, you mentioned, Dr. Ford, you said she credibly presented herself. So my question is about credibility in terms of like in a court of law.
Yeah.
It's arguable that she wasn't credible, that she didn't have like the proper evidence that would hold up in a court of law. So in terms of free speech, how do you think we should maybe put forth ourselves in terms of like when we're analyzing speech content and we're saying that she presented herself credibly? Well, in a court of law that would be different. Is that okay to differentiate?
Well, I hope you won't find this contumacious, but let me just ask you, why do you say she didn't present herself with the proper evidence? What is it that you're saying?
Because she didn't have anything to back up necessarily her claims, right? She didn't, in terms of like in a court of law, it wouldn't necessarily stand because the evidence is either old or she's just bringing forth a claim. The claim.
Well, I think this is the reason I asked you to elaborate on that is that I think that this is a common misconception that I've seen arising out of this, that the fact that Professor Ford, and again, I am not prejudging whom you should believe, but it is said over and over that she didn't have any evidence. Well, and you say it in a court of law. The fact of the matter is that in a court of law, sworn testimony by a victim or a percipient witness is evidence. And juries are instructed, and people go to jail all the time on nothing but viva voce testimony, either of victims or witnesses or co-conspirators, right? No physical. Yeah, one of the things people think when they get on juries is, I can't wait till CSI comes in here, and shows us the DNA. Doesn't usually happen. Usually it's like, yeah, I was standing there, and Shifty said, let's rob the pool hall, and I said, cool, right? That's how you convict people. And the jury's instructed at the end of the presentation of the evidence, you may evaluate testimony by the testimony and demeanor of the witness, which means, what did he or she say? Was it coherent? Was it detailed? Did he or she contradict herself? And what did you think of him or her, right? Demeanor. So in that sense, it certainly was, her testimony certainly was credible. There was no physical evidence, right? Even the president originally said, I found her very credible. I think before he realized he could get away with, something a little harsher. And I think that presented with testimony by those two people in a trial, you might have moved to dismiss, if you're the defendant, on the grounds that we don't know where or when this occurred, right? On the other hand, remember that in a court of law, she would have been allowed to call the witnesses she said knew what had happened, or the people she had confided in contemporaneously. So we might have a very different evidentiary picture. So I think that just as citizens, right, bearing in mind that we don't have the presumption of innocence in public life, that we don't have the burden of proof in public life, just as citizens, I think every person who watched that is entitled, you look at the two witnesses, is entitled to make up their own mind. There's nothing illegitimate about saying, I believe Kavanaugh, I found holes in her testimony. There's nothing illegitimate about saying, I thought she was credible, I thought the way she presented herself was credible. Both are results that somebody could reasonably reach. Does that make sense? Yeah. Yes. Mike?
So do you think that the idea Donald Trump recently put forward, limiting protesting in front of spaces like the White House, do you think that's a limitation on free speech, or do you think that's within his jurisdiction?
I think it's a direct assault on free speech. I think it's not only, in terms of, let me differentiate two things. There's the law of free speech. There's a very rich body of what lawyers call case law that we use to evaluate a question like that. And then there's the concept of free speech, which is something each citizen has, right? And you can't one thing to understand is you cannot be shut down from discussing free speech because someone else is a first-year law student who says, oh, you don't even know about the case of Frigg Aliment versus International Foods. You have your idea of free speech, and what citizens think is free speech in the long run is a very consequential thing, right? So as far as the law of free speech, there's a couple of things I will say. One is, for a long time in this country, really until the 1940s, the principle was that the government could shut any of its property that it wanted, or that it could say some people could use it and some people couldn't. So, for example, Boston Common. The mayor would decide who was allowed to have a rally on. Has anybody been to Boston, seen the Common? It's amazing public space right in the middle of downtown, the perfect place to hold a demonstration. I demonstrated there a number of times, mercifully was not arrested, but that's a different story. It's just the perfect place for public participation. But really, until the 20s, the mayor had the power to say, I don't like this group, they may not use the Common. Beginning in the 20s, we saw an evolution about, because the First Amendment protects the right not only to speak, but peacefully to assemble for redress of grievances. Well, you can't assemble if there's no place to assemble, right? It's not a meaningful right. And in a case called Hague versus Congress of Industrial Organizations, the court finally held that Boss Hague, the mayor of Newark, Jersey City, could not have his police beat up union organizers who tried to make speeches in the parks. They would come in and try to organize workers. The police would come, knock the hell out of them, and throw them out of the city. And Norman Thomas, the socialist candidate for president, was one of them, repeatedly beaten quite badly on the grounds that the mayor says you can't speak. He would say, you can't do that in my town. That's a direct quote. The court in this case held, and I can almost quote it verbatim, since time immemorial, streets and parks have been held in trust for the public, right? They don't belong to the mayor. They don't even belong to the government. They belong to the public for the purposes of peaceful assembly, right? So you start with the presumption that a public space like Lafayette Park, and you've probably all been to Lafayette Park, right? You've seen what a wonderful, I was there a month ago protesting against family separation, a really remarkable demonstration that was organized on a few days' notice. It's just a perfect place to register your dissent or support for things that the president is doing. You're in sight of the White House, right? He wasn't there, so it's not that you have a right to be heard by him, but you have a right to assemble. The president and the Park Service now want to do away with that. They want to close off, for most people, they want to close off Lafayette Park. They want to move protests quite a distance, most of them from the White House. And they want to charge fees for people having protests there. And there are cases on both those things. Hague versus CIO, the case I just told you about, I think basically says, unless you can show some special reason why this property should be off limits, right? I mean, you don't get to protest at on the missile range, or where they're about to launch the rockets, or in the nuclear power plant room, or various other places that are really used for other things. But in space that is open to the public, like Lafayette Park, the presumption is the public can use it under appropriate conditions. You can be required to get a permit. You can be required to observe certain conditions. You also can't be required to pay, a large fee. You can sometimes be required to pay an application fee, the cost of processing, and so forth. So if the law of free speech remains as it is now, it seems to me that this move by the Park Service, if they go ahead with it, we don't know if they're going to, will be contested in court and should lose. And I think it should lose not just legally, but by golly, that's our park. It's not Trump's park. It's not the government's park, it's our park, and it celebrates one of the heroes of our independence, a person who came from France and risked his life so that this country could be independent and free. And the idea that the government wants to take it away because I think the occupant of the White House doesn't like hearing protest ought to disturb us all. Yes, over here, Mike. Mm-hmm.
Personally, do you believe that is true? I know like a lot of students are complaining, especially on the right side, about how college campuses are censoring voices essentially and like not allowing speakers that are melting to the right on their campus. A lot of people are complaining about that. Do you think that is true that the First Amendment, because they're not letting these right speakers on campus, is being assaulted?
Okay, I think that's an important question. And how many people saw Josh Blackman when he was here? Did anybody see Josh? I think Josh, who is a very conservative, libertarian law professor, Josh, among other things, is counsel for the guy who wants to put 3D printer instructions on the web so that everybody can make their own guns at home, because he says that's liberty. I tend not to agree with him. But Josh went to the City University of New York Law School to make a talk of a kind that occurs on law school campuses all the time, right? Sponsored by the Federalist Society, very conservative, but very influential legal group. And a group of students came there and sort of went, hey, hey, ho, ho, Josh Blackman's got to go, because they had found a statement he made online to the effect that the DREAMer program, Deferred Action for Childhood Arrivals, was illegal, that he thought that the Immigration and Nationality Act did not give the president the authority to proclaim as an executive action a program to protect Dreamers. And so they said he was a bigot and this was hate speech and that he wasn't allowed to speak. And I have to say Josh is kind of a more patient guy than I am. And he sat there and said, let me try to explain. And finally, they fell silent, and he did explain. Now, I think that kind of event is something that we should be very concerned about in any forum, right? That somebody wants to come and talk seriously about ideas. You don't have to go, right? That was my response in law school to most Federalist Society events, is like, that's nice, have a good time, right? Or I would go and listen. Sometimes I asked questions that were, challenging. I don't think I was ever rude, but sometimes I was pretty direct. Those things are all, within the universe of discourse. And to the extent that we try to recharacterize political points of view as hate speech, that's something that needs to be watched fairly carefully, right? Am I too low or too high?
Too low.
Okay. All right. On the other hand, there is something to be aware of that's a little bit like the Bible believers thing, right? That there are some things going on campus that are portrayed as affirmations of free speech that are actually attacks on free speech on campus. They're actually attacks on academic freedom. And I think, you probably are aware of things like, there was going to be this big free speech, I can't remember, festival of free speech on the Berkeley campus. And they announced that, sort of every conservative troll whose name they could think of was going to speak. Ann Coulter and Milo, what's-his-face, and so forth. They're all going to be here, and they're all going to say outrageous things. Right? But it turned out, actually, they didn't have half of the people. But it did provoke disorder on that campus, and that disorder was sort of used and is used and is consistently being used as an assault on the independence of the campus. We've got legislators demanding that people be fired or that funding be cut and so forth. So, I think it's worth thinking about the context in which these things take place. And I really regret the impulse. These were law students that led law students to find something on the internet and then think that they needed to go and try to prevent, this sort of harmless law professor from talking. At the same time, I think there is danger to free speech, but I'm not really sure it's all coming from students who are concerned about hate speech. I think it's very complicated. Now, I will say we had an appearance at the University of Baltimore by a lawyer who represents the Alliance Defending Freedom. The Alliance Defending Freedom, very important religious freedom litigating group in front of the Supreme Court, but has also been designated a hate group by the Southern Poverty Law Center. They have the best one-loss record of any advocacy group in front of the Supreme Court. And I brought in a speaker I knew, and my students were, particularly the lesbian, gay, bisexual, and transgender people were furious because this group is very opposed to their rights. And they came and they asked hostile and direct questions, and the event was really wonderful, and I was so proud of them because I think that actually is the kind of thing that ought to happen on college campuses. That's probably more than you asked for, and it also is elaborately not an answer, but
Sorry, I was just going to say about something for a few minutes, but kind of going back to the whole credibility of Dr. Ford wants to bring it back to free speech. I think that's something we can forget is that there was a question that she was credible because it wasn't clear in the trial. It's the job of the question whether or not he was credible to be a Supreme Court justice. And I also think that's something,
I was saying what? I'm sorry.
the speaker you were talking about, Milo, what's his name?
Yeah, Milo, what's his face?
I said, do you think that there are consequences for free speech, like whether or not we stop people from speaking? I don't think we should necessarily stop people from sharing their opinion, but do you think that there are appropriate consequences for free speech?
I think if people understand the question, and if I understand it right, I think this is the nub of what we probably need to talk about. What are the consequences of free speech? Just to back up before that, I will say two things about the Ford Kavanaugh case. Let's not forget, first of all, that even though Dr. Ford was probably the least powerful of the three speakers, her speech did have consequences. It is, again, we've got to consider, possibly she was wrong. Possibly Kavanaugh didn't do the things she alleges. His life, of course, has changed forever. His career has changed forever. Those words cannot be unsaid. In that sense, you can understand that if he didn't do it, why he was so upset. Now, I honestly think the man needs a little help handling his emotions, but that's a different question. The other thing about testimony is one of the things that is considered in court is what's the motive of the witness to lie or tell the truth, right? The motives of the three we can assess to what extent Dr. Ford had a discernible motive that might undermine her credibility. You can ask yourself to what extent Judge Kavanaugh had a motive not to tell the truth if it would help him get through the process. And finally, it's almost irrelevant to talk about Trump's motives, for not telling the truth. That's like saying, what is a fish's motive for swimming in water? It just seems to be his style. But nonetheless, you can ask, his attack on her in front of a political audience clearly had a political motive and apparently had some, political consequences. Now that's to one side. The question is, what are the consequences right, for free speech? What should the consequences be? And we live in a world where we believe that we as Americans have free speech. We live under a regime of free speech. And to a large extent, we do. You know, to a large extent, the American system, the American doctrines that protect free speech are very powerful and basically good. You know, I basically support the law that undergirds free speech. But I think we need to understand that there are other views of this issue, that other places in the world look at it differently, in part because of their own experience. Okay, and we are frequently, in the American media, England and France and Germany are frequently ridiculed because they do have laws that punish hate speech. That in Germany you can be jailed for displaying Nazi regalia or a swastika flag. In France you can be sued or fined or perhaps even imprisoned for suggesting, for engaging in anti-Semitic speech or anti-Muslim speech or so forth. And this is often portrayed in American discourse as a kind of squeamishness. You know, these people are not brave enough to have real free speech. But I think that to some extent that represents a failure of historical memory on our part, because those societies lived through the rise of National Socialism and the eventual spread by armed force of the Nazi ideology until the entire continent of Western Europe was under its control. How did that happen? This was a question that caused anguish among educated people in the wake of the Second World War. It was a shattering event in our idea of what Western civilization is and what Western values are. In the country of Goethe, in the country of Beethoven, you know, in Germany, which was considered, Kant, the height of civilization, how did this bestial, anti-Semitic, murderous ideology attain total power to the point that it could exterminate, 12 million people, 6 million Jews and 6 million others? How did that happen? And one of the conclusions that was drawn was that the rise of National Socialism, like to some extent the rise of Stalinism in Russia, was in part a consequence of the creation of mass media. That we lived in a different world. When the American First Amendment was written, newspapers were the primary way people got their news, or the town crier. Now we have radio, TV, loudspeakers, we have film, and that the Nazis very skillfully used these means of free communication, because in Weimar Germany, before Hitler took power, there was enormous freedom of speech, to systematically dehumanize their enemies, to stigmatize Jews and others as non-human. And I remember I took my son to the museum at Yad Vashem in Israel, the Holocaust Museum, and they have a display there that shows a lot of the propaganda that the Nazis used. And one of the things that we've never forgotten was a cartoon, an animated cartoon that was shown to children in Germany that has a kind of nest of flies. And this nest breaks open, and Jews come out with wings, little bitty Jews, who fly all over the world and infest countries and infest people. And my son said, "Oh my God, I can't imagine what it would be like to see that as a child," right? So in reaction to this, at the end of the war, these societies, which remain free and democratic societies, it said there are some limits on what we're going to let people use free speech in this environment to do. And one of them is to demonize social groups. And in fact, international human rights instruments to which the United States is a party say that it must be illegal to do that. So at that time, 1945, 1950, American law said the same thing. And there was a case called Beauharnais versus Illinois in which the Supreme Court said, yes, it can be made illegal to libel races or religions because it prevents disorder. Now, we evolved into a whole different approach, and the reason we did has to do with our history, and I think it's really important to understand, and that is we got to the 60s, and you had the civil rights movement and the anti-war movement, and movements like this began to originate. And I remember this vividly because I was a young boy at the time. And people said, this Martin Luther King, he's getting people to hate white people. He's going to kill, there's going to be a race war. He's going to kill us all. I grew up in the segregated South. I know how people thought about this. And there was a systematic attempt by the Southern governments to shut down speech about civil rights on the grounds that it was hate speech, on the grounds that it would produce race war. And so finally, by 1965, the Supreme Court comes up with this key case, which is the case that the Nwanguma case relied on, called Brandenburg. And in that case, a bunch of Klan members were sitting around a cross, and they were put on TV saying horrible things and burning the cross, and they were arrested and charged under one of these hate speech laws. And the Supreme Court said, you can't do that. You can't make that whole category of speech illegal. You have to show that what the person said at that moment in those circumstances might lead to violence. And that's where we are now, right? It is not, the hate speech context is legally irrelevant. And that's probably right. That's probably the way a big, diverse society like this one needs to run its free speech. But we shouldn't pretend it doesn't have costs. And I think that the people who ran the Arab American Festival in Dearborn could talk to you about that. You know, we had a space where we were allowed to express our identity. It's gone. It's gone because, you know, people representing certain majority views didn't want to tolerate it, and they found a way to shut it down. There are costs to protecting what we protect, and I think that we need to think about that. And that I think I'll use to just end this, and then we just throw it open for free-for-all, because there are really two views of the American First Amendment, and one of them, which I think you're going to encounter a lot, is what I call the triumphalist view. You know, and I have, you know, really wonderful scholars and friends, Jeffrey Stone and people of this sort, who write books about how wonderful it is that we have the freest speech in the world. And the idea is that because American speech is so free, we are progressing toward better and better societies because free ideas can come out and everybody can consider them and think about them, and then we adopt the good ones. And isn't it wonderful? And that's one way to look at it. I think the better way to look at it, though, is what I call the tragic view, right? We have free speech in this country because everything else is a lot worse. Everything else maybe puts in the hands of the Southern white governments the chance to shut down minority people. I remember when I was living in Richmond in 1991, the students at Stonewall Jackson High School. Stonewall Jackson High School, I think it's now called Barack Obama High School, but that's a piece of progress that didn't happen for a long time. African American students at this school went to the principal and said, can you please make the white students stop wearing Confederate flag shirts? This was causing, you know, the Confederate flag is a symbol of great division, and it's a symbol that carries a coded message of racism. It always has, that's not new. And so the principal met with people from the school board, and he announced the new rule. And the new rule was you couldn't wear a Confederate flag t-shirt, and you also couldn't wear t-shirts that said X on the front. This was when the Malcolm X movie was new, because Malcolm X was hate also. Right? And I think this gives you an example of why we want to be very careful before we give government officials the power to designate what's hate speech and what isn't, okay? So in the tragic view of free speech, we protect it because the alternative is worse, A, and for another reason. And this reason, I think, is very sobering. It certainly sobers me. And I always start my First Amendment course at UB by saying, you know, there are three philosophies we might use to protect free speech. Do we protect free speech because speech is harmless? You know, sticks and stones may break my bones, words can never hurt me. Do we protect free speech as long as it's harmless, right? So the idea is most speech is protected, but some isn't. Do we protect free speech unless it's harmless, meaning we're going to look really hard at every instance of speech and protect some and some others? And I think that's the three ways most people think about it. But I have a fourth way. And I'm going to throw this out here, and then I'm going to just stop, and if you don't want to ask questions, that's fine. I think we protect speech in this society because it does harm. Free speech does do harm. Free speech did harm to Mr. Nwanguma. It did harm to the Arab American Festival. It arguably did harm to Professor Ford, depending on what you think of the credibility of it. But the reason that we protect it is that we take a really sober look at the society we live in. We all have this vision. You know, there was this thing, Senator Sass was out, he writes a lot of books, and he was out touring about a book he wrote about, you know, how great it was in the old days when you lived in homogeneous communities and everybody went to the football game on Friday night. And my reaction to that was, those weren't homogeneous communities. They were communities where the people who didn't meet, who were marginal, were excluded, and so you didn't have to think about them, right? But the fact of the matter is, American society is, and always has been, a huge, diverse collection of groups of people divided by economics and region and race and religion, fighting over resources, fighting over cultural dominance. That's what society is. Society is not the peaceful, you know, how many people, did you guys used to read Archie comics? Remember, you know, what is it, Riverdale, right? And Coach Cleats and you know, the chocolate shop. Society was never like that. It's always been a battle, war to the knife. And we let people fight it out by speech because that keeps them from killing each other. And that's not a very elevated, happy view of free speech. But that's what I've come to looking at these cases. And I think that might inform your decisions about what speech should be protected or not. I leave that to you, but I'm going to stop now and see if people ask questions. Now, you know, what I do in my classes in Baltimore is, you know, I'll stop. I don't think you can teach. I don't think you're teaching people if they don't ask questions. So I just stop and I say, look, and this is true, I'm a state employee. You know, I get paid by the hour. I'll stand up here by myself. You don't want to ask questions, that's fine. Eventually someone will ask questions. So let's see, who wants to ask a question? We've got way in the back. No, you're next. Okay, you know, there's a lot of echo here, plus I'm an old man and have bad ears. Yeah.
Okay, so my question is, what if I use my right of free speech, and even worse, hate speech, and the person I'm using it against commits suicide or harms themselves, or like my speech has direct consequences to their well-being? Shouldn't there be like boundaries to that?
Well, you know, yes is the short answer, but how do we enforce those boundaries, right? I hope everybody got the question, is that, you know, what about speech that is bullying, right? Bullying speech either online or in person that eventually causes self-harm by the target. I will say that in law, there is a tort, you know, a civil action you can bring called intentional infliction of emotional distress. That can be accomplished entirely by speech. You don't have to do anything else. You know, if I go to someone, you know, someone who's just lost a loved one to murder or something, and I go and I say to them directly, you deserve this misfortune, your child is in hell, etc. That I can be sued for that, right? There's also an offense, a category of offenses called fighting words, which is when you go directly up to somebody and you say something that really is calculated to or objectively likely to make somebody hit you or react in some violent way. That can be punished as well. Now, the question of sort of more systematic bullying and online bullying is we haven't figured out how to deal with that. It can also be covered by intentional infliction of emotional distress. The problem is the logistics of doing it. Right? It's not the theory of responsibility. The theory of responsibility says that if you do that and you're intentionally wanting to make the person miserable, you don't have to want them to kill themselves. You just have to, what you're doing has no other purpose except to really hurt the person. Then you're liable. The problem is, how do we catch you? How do we hold you to account? And so that's a second order question, and I don't have the answer to that. Is that helpful? There was a gentleman down here. Yes. And the question is, what group? African Americans?
What does the average American?
The average American, okay. I have to say, speaking of sobering things, right? The question is, does the average American support free speech? Over the years, over and over, we've had public opinion researchers go out, and say to people, hello, person in the street. Let me read you a proposition and tell me if you agree with it. Congress shall make no law respecting abridging freedom of speech or of the press. What do you think? Majorities always say, no, that's a terrible idea. Why? No, we shouldn't do that. People believe in free speech for themselves. And unfortunately, there is a tendency in mass society to identify with powerful people. So I think the president and his remarks at his rallies, if you criticize that, you're criticizing free speech. But if it's someone powerless, it tends to be much more like this could be harmful. This person could upset the apple cart. And I don't know how to get that value across to people. I would like to see us as a society, really embrace the idea that unless there's some really good reason not to, then we're basically going to protect people's speech, whatever the hell it is. I'm not sure there's ever been a golden age of that. Certainly in wartime, during World War II, there was a lot of restrictions on what you could say. In the period after that, in the 1950s, there was the kind of Red Scare, and all kinds of speech was shut down. The 60s, a lot of speech flourished, but that's almost an anomaly. And I think we live now in a culture, and this is right. Remember I said that if you read the press or everything, you'll find that the big danger to free speech is on the campus. Students are the ones who are destroying free speech. I think free speech is under assault from every aspect of our society, beginning with the White House and forwarding out, because people don't fully embrace a coherent idea of why we have it. They know we have it. They think it's got to be a good thing. Therefore, it must mean whatever they see as good. That's kind of sobering, but I think it's true. We've got a lady right here.
So you mentioned the Confederate flag, and I grew up in the South as well, and personally, I think that the Confederate flag is...
I'm really sorry, but Well, you know, it's the echo and me having old ears, so if I come down to where you're actually talking to me.
All right.
Yeah. Hi.
Hi.
Nice to meet you.
Nice to meet you. Do you think that the Confederate flag is hate speech?
I do. That doesn't, now that's step one, right? I grew up with that. I grew up with the flag. I grew up, you know, I will tell you, everybody is a prisoner to some extent of their own experiences. I remember when I was young asking my mother in a sort of carefree way, what was her first memory? Mom, what was your earliest memory? You know, I remember being at the beach. That was mine. She said, my first memory was Christmas. And I think I was 3 or 4. And my mother opened her present, her gift from my father. It was a pearl-handled pistol. And my father said to my mother, you need this rose because so-and-so, who was the head of the local Klan chapter, has said he's going to kill all of us. So for the whole rest of her life, my mother had this terror of the Ku Klux Klan. You know, and I used to go out and throw rocks at Klan guys. You know, I wasn't really afraid of them all that much. But I couldn't tell my mother because she would get hysterical with fear. So some of the symbols that are used around that whole statement of Southern identity really are very powerful. And I think I know there are people who display the Confederate flag who do not think of it as hateful. But I think that the effect on the onlooker is very powerful often. And so for that doesn't mean I think you shouldn't be allowed to fly it, right? That's a different statement. But I do think that it is not, you know, people say heritage, not hate. I don't believe that, right? And I think if you push a little bit on the people who are fighting to preserve the Confederate monuments, you will get some evidence that can make you feel skeptical about heritage, not hate. Does that answer your question? Yeah.
Hi. So I was curious if you could talk about the aspect of free speech in the prison system, because as we all know, the prison system is not like normal life.
Yes.
And so, like, there's a lot of opinions on the system.
I think that, you know, there's certainly legal doctrine that says certain kinds of speech can be restricted in the prison context in the interest of security. I do think that we as a society have tolerated prison authorities moving way past what we should allow. And I don't know whether you've followed any of these things, but in a number of the prison systems, state prison systems, we've now got systems where either there's a list of books you can have, or you can only buy books from one vendor and only buy the books that vendor makes available, or prisoners can't have books in their cells. And I think that, first of all, that ought to offend us as people who believe in free speech. There is certainly no provision in the Constitution that says that if you are convicted of a crime, you lose your freedom of speech. Even while you're in prison, you have freedom of speech. The question is, you know, how you exercise it can be limited. Free speech is quite important, and free speech doesn't just mean you can read a book in your cell if you can happen to get it there. We need to be, I mean, among other things, you know, if you think about the people in our culture, the many, many figures who have done fantastic things while in prison or have reformed themselves while in prison, like Malcolm X or people like Martin Luther King, who wrote, you know, one of the most powerful documents in all of the pantheon of American political thought, the letter from Birmingham jail. The idea that we're going to shut down that whole category of people from writing and thinking and expressing themselves, it's shocking. And it seems to pass without comment. We've become very tolerant in this society of restraint, incarceration, mass incarceration. We're all becoming aware of the consequences of that. But think about it. We've got tent cities now in the desert where children are being held, hundreds, thousands of children being held who've committed no crime. being held under prison-type conditions. And society is tolerating this because we have become accustomed to the idea that we are an imprisoning society. And that is really scary. It's scary in free speech terms, and it's also scary in just regular general free society terms. There was somebody, yes, hi.
Hi. So I had a question about the Kavanaugh hearings. So some people on the conservative side of the aisle claim that, or were afraid that Dr. Ford's testimony was engineered by like Democratic Party consultants. Now, while I think that's ridiculous, I was wondering, is there any like historical precedent to like fuel that kind of fear, where like a political party has ever like engineered an event that like creates like an entire country having like a cultural war? Like, has that ever happened?
Well, that's a wonderful question, and there's two parts of it, okay, for those who didn't get it. Like, are there, they said, that Ford's testimony had been engineered as part of a political operation, and has there ever been anything like that, right? And I will say two things that are quite distinct. The first is about that particular accusation as it pertains to Dr. Ford. I think we're dealing now with a very profound social archetype that's in a lot of people's minds. And, I don't know whether people will agree with me, and I'm delighted if you don't, but I see our society as profoundly shaped by a sort of patriarchal view. A view that says that the Trumps and Kavanaughs are worth more than the Fords and Anita Hills. And one of the responses that has come up over and over in the history of gender relations in this country is when an accusation is made against a powerful man of sexual abuse, sexual misconduct. This goes back to Jefferson, for God's sake. The question is immediately asked, who put you up to this? Not, did it happen? Not, what did you suffer? But who put you up to this? Who made you do it? Who told you to lie? Who told you to hurt this good man, right? That's a thing that is part of sexual dynamics. Now, you asked a question stemming from that isn't limited to the gender context. And that is, has anybody ever engineered a hoax that actually had a profound effect on society? And, the answer, I think, is rarely. It's kind of hard. Americans aren't good at conspiracies, right? Because we like to talk too much. I mean, as far as I'm concerned, if the CIA had killed Kennedy, people would be writing books about it now. You have to say, I was there, I killed him, right? That's just the American thing. But every now and then there's a conspiracy that has some success. And the one I'd like to bring to your attention has to do with the word miscegenation. Do people know what the word miscegenation means? How many people know what that means? Right? Miscegenation refers to sexual dealings and the bearing of children between racial groups. So Loving versus Virginia had to do with Virginia's anti-miscegenation law, that white people could not marry black people, right? The word miscegenation is an invented word. And it was invented in 1864 by a group of ex-newspapermen working for the Democratic National Committee. And they wrote a phony book called Miscegenation, The Solution to America's Future, written supposedly in the point of view of a Lincoln Republican. They made up a name for the author, and saying, Lincoln is doing the right thing because we have to free the slaves, and then blacks and whites will mate, and America will be a mongrel nation, and that'll be great. And they printed up this book, and they mailed out hundreds of copies to prominent Republican politicians. And then people, it's a little bit like O'Keeffe, They would go and say, what do you think of miscegenation? Because they were hoping people would say, oh, this is a great book. It didn't work all that well. Lincoln was reelected. That had a lot to do with the results of Cedar Creek and the fall of Atlanta and so forth. But it really was a very systematic attempt. And it did have an effect on our culture. We still use that word today. So, yeah, it can happen. It's hard as hell to pull off. And I always think that when you're presented with a cluster of unexplained phenomena, your first heuristic ought to be, maybe this is just happening. The presumption ought to be stuff just happens, right? Why was the Ford thing handled so badly? Judge Kavanaugh said it was a conspiracy to hold this thing till the end and then use it against him. I don't think so. I think never attribute to conspiracy what simple incompetence will explain. I just think it was just badly handled because the people who were handling it were bad at handling. But every now and then there is a conspiracy. So I wish that weren't true. You're talking about COINTELPRO in the 60s? Yeah, okay.
So, would you call that an attack against free speech, and would you say that that's justifiable?
Was it justifiable? For those of you who don't know, the FBI conducted sort of a massive, not simply intelligence operation, but actual involvement in the affairs of various protest groups beginning in the 1950s. They infiltrated the Communist Party with informers or actual FBI agents. And that moved forward, that same practice moved forward into the 60s. There was infiltration and surveillance of civil rights organizations, wiretaps of Dr. Martin Luther King, which they used to gather evidence that he had been unfaithful to his wife, and they used that evidence, they played that for powerful politicians to influence them against Dr. King, and they used it to attempt to persuade him to commit suicide. That was the real aim of the operation. And is this consistent with free speech? And the answer is no, right? The answer is when the state is always listening, then your speech isn't free. If there's no place where you can talk privately, there's an old Soviet joke about this, in which one worker says to the other, Ivan, tell me, just between us, what do you think of Stalin? And the other guy goes, shh, don't talk here, we can't talk here. We go down the street, we go where there is no one. No one is listening. We row to the middle of the river. And they get there and he says, just between us. I like him. So, you need to have a private moment to say whatever it is that you really think. I have been in situations, I have covered as a newspaperman situations where the FBI was involved in various things like this. It's very sobering. But the worst thing the FBI did, I have to say, and then, maybe, I don't know if we should take a break or...
Take the last question.
Yeah, okay. You can get your file from the 60s, from the FBI, under the Freedom of Information Act. And so I thought, this will be really interesting, because I was a student journalist, and I was editor of my newspaper, and started an underground paper, and so forth. So we sent off, and we had to threaten to sue them, but we got the file. And the file came back. And this was the worst thing. This is beyond question. The worst thing the FBI did. There was practically nothing in it. They didn't care what I was doing, right? There was just a thing saying, have you ever heard of this guy? Is he in the Communist Party? And there was an answer, no. That was my file. I was so insulted. What am I, chopped liver, right? So anyway, that's the worst thing they did. Okay, question. Last question here.
I like what you said about the tragic view.
Yeah.
Free speech, but I was thinking about how, in this sense that we're doing, if people can battle with each other through free speech, and like you said at the beginning, we had to look at the context and the context of power in the situation that people were speaking to one another. So, in this situation where some people have more power than others and can't be removed from that, the power can't be evened out. How do you even the playing field where that battle can happen? How do you lift some voices up?
That's a wonderful question. That's a wonderful question, and I would probably, that's a good place to end the formal part of the proceedings. Because that is missing, as I said, this whole question of the imbalance of power is missing from our First Amendment dialogue in this country. It's not just missing, it's off limits. And I will give you an example that I think most of you are aware of, and that is campaign finances and the questions that rise out of cases like Citizens United, in which the court has basically said that the expenditure of funds, the kind of use of money for speech purposes such as TV advertising, mass mailings, internet ads, and so forth, cannot be restricted, and particularly can't be restricted in the interest of making elections more fair. So that if I'm running for, I'm a candidate of Party A, my party is the Party of Poor People, someone else is running as a candidate of Party B, which is the candidate of, let's say, the Koch brothers or someone of that sort, and that person is able to outspend me, or groups supporting that person are able to outspend groups supporting me by 10, 20, 30 times, to the point that my message really can't get out. They said, the government is powerless. And there's a famous phrase from a case called Buckley versus Vallejo that says, the notion that we may restrict the speech of some to enhance the speech of others is wholly foreign to the First Amendment. That comes from the 70s, and the case law all comes from that. And there's no citation for that. The court doesn't explain why it says that. It's demonstrably false. We do it all the time, okay? And imagine this context, where we are in a free speech type situation. And imagine that some individual gets up and says, I have 16 questions for you, me that is, and I'm going to ask all 16. Question 1. And then, I say, in my foggy way, thank you, that's a question, can we hear from someone else? No, I've got the microphone, I'm going to ask you the other 15 questions. Say, well, sir or madam, you need to share the microphone with other people. This is an educational environment. Everybody needs to get to speak. No, the idea that you as an authority can restrict my speech to enhance the speech of others is wholly foreign to the First Amendment. You're like, what? Wholly foreign? What are you talking about? What do you mean, French or what? No, it's not. We do it all the time. We do it at city council meetings. We do it in all kinds of situations where you're told you get 5 minutes to comment, then the next person gets to comment, and so forth. And so I think we made a misstep back in the 70s. Now, how you carry it out in a fair way is a different question. But right now, we're very far from really understanding what at least inequality of wealth can mean to free speech. And one of the things that the founders, and I'll stop after this, but one of the things the founders of this country profoundly believed was that a free Republican form of government could not coexist with sharp imbalance of wealth. And what we have and what has arisen in this country since 1980, I think simply is toxic to the very idea of democracy. We cannot continue to be a democratic country and tolerate the inequality of wealth that is present in this country. And that's something we all need to think about. So thank you for your indulgence.